Hello, everyone. Welcome to Trustee School, June 15th, 2024. I'm Ethan Welch, attorney here at Hickman Lowder, and we also have George Aljoe presenting as well. He's an attorney here at Hickman Lowder. We practice special needs and Medicaid, elder law. That's our bread and butter. And today we're here to talk about Trustee School because we administer a lot of trusts, special needs trusts, wholly discretionary trusts, and just irrevocable trusts for our clients. And a lot of our clients are trustees as well. And we put together these presentations for our trustees and our family members of trustees and trust beneficiaries. So they have a general refresher of their responsibilities and their duties in regards to their beneficiaries. And, I anticipate this presentation to last an hour and a half to 2 hours. You can stay as long as you want. We're not going to be offended if you do have to go. The presentation will be available later, and the presentation slides. So let's just get started. So our goal here is to review government benefits, explore the relationship between these government benefits and the trust administration of these trusts, understand trustee responsibilities, and just discuss trust administration, what that entails, and the use of care managers and other delegates that you might appoint to help you along the way administering these trusts. So trustee responsibilities, sometimes in most cases, we have children or other family members that become trustee once their parents pass away, and now they're the trustee of this trust over their loved one, over their sibling, over a niece, a nephew, or even another family friend. So now they're taking over once the trustee passes away or becomes incapacitated. And the first question is, well, where do I start? Well, the first, rule of thumb is we got to read the document. We've got to make sure, what this document entails. And after reading the document, I'm sure that hundreds of more questions are going to pop up. So that's when you have to meet with your attorney to discuss what these provisions mean and how are you going to use this document to benefit this beneficiary. This beneficiary that's most likely disabled, most likely on government benefits. How are we going to protect these funds and also protect the benefits that this beneficiary is having? So as trustee, according to Ohio law, you are now a fiduciary, and a fiduciary has obligations. One of the, most common sense obligation that you have is, well, I'm going to manage this money and manage these assets for the benefit of this beneficiary. It's not going to benefit me as trustee. I am in a fiduciary capacity. So if I, misuse these funds, if I use these funds to pay my bills as trustee, that's a problem. You are essentially stealing that money, and you could have civil or criminal consequences of doing that. Because these are special needs trusts that we were talking about, and we are using these funds for the benefit of a disabled individual, you have an even higher standard because you have reporting requirements to government agencies like Social Security, like Medicaid, Job and Family Services, in order to retain those benefits. So it's even a higher standard than a typical trustee. These financial responsibilities that a trustee has, you have the duty to invest these funds. We don't want to invest everything in Apple stock. We don't know what Apple is going to do next year. So we want to diversify. We want to make sure that we're dispersing monies correctly. We want to use this money for the benefit of the beneficiary, but because these beneficiaries are on Medicaid and Social Security, distributing money directly to that beneficiary could hold consequences to their benefits. So there's ways of dispersing money to make sure that these funds won't disrupt any benefits. We have to make sure we're keeping good record keeping. We have to make sure that statements are being filed away, because these statements are going to be used to present to Job and Family Services and Social Security in the reporting category here. We want to keep good records of any disbursements that we've made. We don't want any situation where Job and Family Services call, as part of a redetermination for Medicaid, they ask the trustee, well, what's this $5,000 payment here? And you have no idea. That $5,000 payment was for a wheelchair, and here's the receipt, and here's the invoice that I received. Keeping those records, can be cumbersome, but it's as simple as just making a purchase, putting that in a folder, putting that receipt, putting that statement when it comes in, put it in a folder, so that way, if those questions arise, oh, it's on June 15th, I got the statement, I got the receipt, it's all right here. The trustee may have to file taxes if the trust is making income, and there's capital gains and interest income that the trust produces. Well, you have to file a tax return and pay any taxes that are due. As part of our work, we designate our trustees as advocates for our disabled individuals. So they are seeing, what does this individual need on a daily basis, a monthly basis, a yearly basis? What kind of needs does this individual need for them to better their life? And finally, and I mentioned this, we have a higher bar for trustees of special needs trust because we have these benefits required. But if you put yourself out there as I'm an attorney, I'm a CPA, I know how to handle these trust matters, well, the standard becomes even higher then. You have a higher standard than a layperson because you should have known how to handle these assets. So it's an even higher bar for those that have professional experience with these trust matters. So like I mentioned, we don't want to use this money to benefit ourselves as trustee. The default rule here is there should be no self-dealing between the trustee or immediate family members of the beneficiary. So that means no borrowing from the trust for the benefit of someone else, no investment in the trustee's business. If the trustee is, a landscaper and they need equipment to purchase a new lawnmower. Well, you can't use the trust fund to purchase a lawnmower for your business. That doesn't benefit the beneficiary. There's no sales to or purchases from the trust that would benefit the trustee. We're trying to benefit the beneficiary once again. And finally, we don't want to commingle any assets with the trust fund. So we don't want to commingle the trustee fund with trustee money, the individual's money. And we also don't want to commingle the beneficiary's money with the trust money. So keep their income aside, keep their assets aside, separate from the trust fund. Then we have delegation. We want to be able to delegate duties to professionals. Trustees don't have to handle everything themselves. They can hire a tax preparer. They can hire an accountant. They can hire an attorney to help them through this process. They can hire any professional. They can hire a financial advisor to help them invest the funds. Everything doesn't fall on the trustee's shoulders. They can make sure that they're doing a correct job by hiring professionals that are able to do these duties, that they don't have a direct professional relationship as themselves. So we always tell clients to go hire a financial advisor, because we ourselves are not financial experts. We know enough to be a little dangerous, but we don't know the ins and outs and how to invest and what to reinvest with the funds. A financial advisor knows that. Same thing with taxes. We know enough to give you this presentation about a little bit about taxes, but we always tell clients, go talk to a tax preparer, go talk to a CPA, because they handle these issues on a day-to-day basis, and they will be able to, help you, the trustee, and help the beneficiary with the best tax consequences. And finally, as part of my opening segue here, I'm going to segue this to George after this slide. We have Ohio law requires you as trustee to prudently invest trustee funds. It follows the Ohio Prudent Investor Rule, and that typically uses the modern portfolio theory. Essentially, we have to diversify assets. We can't just keep everything in one pocket here. We've got to invest in bonds and stocks and equities and maybe even real estate, if that makes sense. But you can't just invest in one thing, because if the market crashes and that company crashes, there goes all the money. We got to prudently invest this. The rule is there is a 60-40 rule where you can invest 60% of the trust assets in equities and in stocks, and 40% has to go buy bonds or fixed income, and that would be like CDs or places with checking or any account that has an interest rate. So we use that 60-40 rule as required by the revised code.
Okay, so I'm going to jump in here and talk about the reporting requirements. In other words, this is what you've got to make sure that you are providing information to Social Security, other benefit agencies as necessary, and the beneficiary themselves. So, the beneficiary generally has a right to know what's going on with the trust that's being held for their benefit. Now, sometimes the law allows for a trust to appoint someone to be a surrogate for that beneficiary for these reporting requirements. And what that means is that there is another individual who is the one who you would report this information to sometimes there's reasons why you wouldn't want the beneficiary themselves to have this information, or sometimes the beneficiary just simply isn't capable of appreciating or understanding what this information is, and so a surrogate can stand in their shoes so that the beneficiary's interests are best protected. So first of all, you have to provide accountings at least annually, or on demand, reasonably on demand by the beneficiary, of what's been going on with the trust asset. It could be as simple as just a statement of the assets and what income and distributions have been made, tax returns, all this sort of stuff. This is really important because as trustee, you are spending a lot of time and effort to manage this trust, and being able to accurately and comprehensively report what it is that you've been doing allows you to justify any fees that you are charging for administering that trust, particularly for extraordinary trustee fees, where you've done something really out of the ordinary. You had some particular issue that you spent an inordinate amount of time and effort on, and you want compensated for that. Well, you've got to be able to justify that compensation if ever asked about. Many of our special needs trusts are also overseen by the probate court. This is when the beneficiary is not competent and a trust needs to be established for them to shield their assets. The court is going to first grant the permission to create that trust, approve who the trustee will be, and then ongoing have oversight over that trust. So the probate court will require periodic accounting. Some courts want them every year. Some courts are okay with every 2 years. They generally work out sort of day-to-day budgets, but again, something out of the ordinary, you've got to get probate court approval to do that. And then generally to government benefit agencies, Medicaid, SSI, if applicable, they can ask for information whenever they want. But in general, they have an annual or some periodic review, redetermination, renewal, many different sort of names for it. But generally, they check in on eligibility periodically, and you have to provide information at that time. So we talked about that compensation, and the way that we draft our trust is, compensation has to be reasonable. Well, what does that mean? Our trust, we draft them so that it gives a few examples of what reasonable compensation would be. One of those examples being, what the probate court has established as a reasonable schedule for fee compensation. So this is kind of an example here. So, a trust that has $1 million or less in assets under management, the trustee is entitled to annual compensation of $12 per thousand. So, I went to law school, so I wouldn't have to do math, but we can work out the arithmetic there as to what $1 million would be, and 2 million, and then 2 million after that, and then the remainder. So you can kind of see how that breaks down. Reason really being is that once you get over a certain threshold, the complexity of managing those assets really doesn't get much more complex. So that's why the rate per thousand it diminishes. But this would be reasonable, right? So if you've got a trust where you have $200,000 under management, and you're taking, $7,000 or $8,000 a year in trustee fees, well, that's probably not reasonable. That's going to be scrutinized and probably not considered to be reasonable. So this kind of gives you a guidance as to what trustee compensation should look like. So in general, these last couple of slides were applicable to any trust that somebody would be managing, but there is particular considerations with a special needs trust. Again, that primary beneficiary may have diminished capacity and ability to understand or defend their own rights. They also may heavily depend on various social services, public benefits that have their own Byzantine and arcane rules about eligibility and how they treat the trust and how the trust intersects with that. In addition to that, a special needs trust to be a special needs trust for the benefit of an individual, at least when it's funded with that individual's own assets, the state has rights to, as a creditor of that trust, when that beneficiary passes away. That it has to provide that the trust reimburses the Medicaid in order to just simply be a special needs trust and to be an exempt asset in the first place. So there's that overlay there. And then the primary beneficiary, they could rely exclusively on this trust for their needs, or this trust could be there simply for purely supplemental things, because the beneficiary has other income streams or other benefits, or is able to meet their day-to-day needs using their own resources. And again, the courts are very often involved with our special needs trust, particularly for individuals who have developmental disabilities, who have turned 18 or have received settlements from childhood disabilities. The court's going to be involved there because that individual has been incompetent since reaching adulthood and has been under guardianship. So these are sort of specific special considerations when we're talking about special needs trust. So what this means is that in addition to managing the money and doing the prudent investing and reporting to beneficiaries, all those things that Ethan talked about, the trustee also has the job of looking after the individual's benefits. Are they getting what they need? Or is there something else that could be available to them? Who's taking care of that beneficiary? It may not be the trustee who is the primary caregiver, particularly if you're taking over from mom or dad or whomever as a successor trustee. You haven't been their primary caregiver. So how do you ensure that beneficiary is getting the care that they need? How do you make sure they get the services and equipment that they require? And if you do have somebody who is another family member who is the primary caregiver, navigating those family dynamics, right? I mean, you've got this trust fund that has perhaps quite a significant amount of money in it. The caregiver needs to be made to understand that this money is for the person they're taking care of, not for the caregiver themselves or for the family in general or anything like that. What we frequently will do to help sort of give a structure to these challenges is when we set up the trust initially, we will have the creator of the trust, mom or dad, whomever, draw up what we call our letter of intent. This is not part of the trust for reasons that we'll explain here in a few more slides. It's not part of the trust, but it is the instruction set for how the settlor or the creator of the trust intends and expects the trust to be used, and how that fits in with the overall picture of that they have in their mind for how their special needs loved one is going to be taken care of. So as far as when the trust is going to make a distribution, disbursements, and by disbursements, we mean anytime money is leaving the trust, whether that is to purchase something for the beneficiary, whether it is to pay compensation to the trustee or to some other individual who's acting under the trust, or sometimes payments directly to the beneficiary, although those are generally to be avoided for various reasons. If the beneficiary is receiving any sort of means-tested benefits like Medicaid or SSI, in general, payments that come from the trust, cash payments from the trust to the individual, are considered income to that individual that month. This can cause disruption in their benefits, cause all sorts of problems. So what we want instead is for the trust to pay directly for things for the beneficiary. So if the beneficiary needs new bedroom furniture, don't give the beneficiary $2,500 to go out and buy bedroom furniture. Go buy the bedroom furniture as the trustee and have it delivered to the beneficiary. For SSI, and actually that third dash point there, we will need to amend that, because just this year the SSI rules were updated. There is no longer a restriction on payment for food for for the beneficiary on SSI. It used to be that if somebody paid for food for the individual, then they would get their SSI payments reduced. That rule has gone away now. However, shelter, so rent, mortgage payments, things like that, utilities, that's still not something you want to pay for out of the trust. However, food, now you're good. You can go ahead and order things on Instacart for them. You can have set up grocery deliveries. You can do all that stuff, and that's really been helpful in makes administering these trusts just that much easier. So often the trust owns the building or the place where the beneficiary lives. A typical scenario is mom or dad have lived with the beneficiary. They want the beneficiary to be able to remain in their home after they're gone, and so they have that home placed into a trust for the benefit of that beneficiary. So as trustee of the trust that now owns this property, what's your job here? What are you going to encounter? What do you have to deal with? So, again, care providers. Are you be able to get care providers, to come into the home? Is there a roommate, a live-in caregiver? Can the trust afford to keep this property up? The trust is responsible for paying property taxes. The trust is responsible for upkeep, maintenance, and repairs. And then can the trust make sure to get property insurance on that house? That the trust is the property owner here. The beneficiary lives there, but is really as a tenant. So you have sort of almost a landlord-tenant relationship with your beneficiary in that circumstance. Go ahead, Ethan. All right. I think this is the last slide in my little segment here. Of particular importance for trust, vehicles. Oftentimes beneficiaries, their situation is they don't drive, but many do. Many have the ability, to drive. And what do you do as far as vehicles? Generally, you don't want to have the trust be the owner of that vehicle. Liability issues. If that vehicle is in an accident and liability is on the driver of that vehicle, theoretically trust assets could be on the line if there's liability that attaches because of that accident. You could so then you want to have the vehicle titled in the beneficiary's name outright. And that's generally okay. But the public benefit programs typically allow one vehicle of any value to be owned by the beneficiary without causing any problems for their benefits. If you wanted to add an extra layer of protection there, the trust could take a lien on that vehicle. In other words, if the trust purchases the vehicle for the individual, they title it in the individual's name, but they essentially own all the equity in that vehicle. So again, if there's an issue with that vehicle being in an accident or what have you, the trust is already the primary lien holder, so there's not a lot of equity value there. Another issue is life insurance. You've got somebody who the beneficiary is relying on to take care of them. What happens if something happens to that individual? You now need to hire a new professional caregiver, or perhaps having that person living with the beneficiary is the only way that the beneficiary could stay in the community. And if something happens to that caregiver, the beneficiary now has to go into a group home or has to go somewhere else. And so you need resources to be able to arrange for that new care situation. The trust can purchase life insurance on that caregiver's life, so that there's resources and assets there to help with that possibility. And prepaying for funeral arrangements. Everyone's going to need one. It's probably better to prepay for those funeral arrangements, particularly if you have a special needs trust, particularly if that trust has a Medicaid payback provision in it, because Medicaid is entitled to compensation before any funeral payments, any funeral expenses could be made from the trust. In general, Medicaid estate recovery will be flexible and will generally approve, that the trust assets can be used for a funeral before they take their cut, but you don't want to have to mess with that arrangement. Prepay for the arrangements during life and you avoid it altogether. All right, now Ethan's going to talk about taxes. So if your eyes glaze over, you'll be in good company with that here.
Right. And as I previously said, I know enough about taxes to be dangerous, but taxes should be, you should be going to a CPA or a tax preparer to get a 100% understanding about how the trust should be paying taxes. But in general here, the first thing is, does a special needs trust, does a first party trust need an EIN? And no, it doesn't need an EIN. Best practice is it should have an EIN. You want to try to separate the beneficiary from the trust. And, an EIN, an employer identification number from the IRS is, an easy way to do that. For taxes for a special needs trust, a self-settled trust is assets that the beneficiary had or had legal right to. They had to put the money aside in the special needs trust. That's typically a grantor trust. So all income earned by the trust will be carried through to the beneficiary's individual tax return. That's through a K-1. Any money that's left in the trust is taxed at tax bracket rates, and tax rates are far higher than what an individual tax rates are. So if the trust makes over $10,000, you're in that highest tax bracket. You're being taxed at up to 37% now, where an individual, they have to make over $500,000 to be taxed at that tax rate. So using the beneficiary to pay the taxes is far more advantageous than having the trust pay the taxes. So that raises the question, well, if the individual, the beneficiary, is reporting these taxes, they will have taxable income. Won't that affect their benefits? It shouldn't, because there's a difference between taxable income and benefits income. Taxable income is used for tax reporting requirements. But a typical caseworker at Social Security or Job and Family Services may not know that. That's just the sad truth of it. So in order to counteract any questions from the caseworker, the trustee should retain all, evidence of the distributions that they made on behalf of the beneficiary, and to show that, hey, this person didn't have any true income. The income came from the trust tax return, and it was K1, it was carried over to the beneficiary. Taxation of special or third-party trusts. So that third-party trusts are trusts that are created and funded by the parent or any other individual on behalf of the beneficiary. It's a very similar, a little different for tax reporting requirements. They will have an EIN attached to this trust. They are most likely qualified at or designated as a qualified disability trust. The special needs trust would also be classified as a qualified disability trust. You just get a higher exemption with that designation. If the beneficiary is disabled, then you get this designation. Any undistributed income would be taxed to the trust. Distributed income would be taxed on the beneficiary's tax return. So once again, you want to try to push as much income as you can to the beneficiary. If you have a high net worth trust here, and it's making tens of thousands of dollars in income, then, and you haven't made many distributions that year to the beneficiary, then the third party trust would be taxed, at that tax rate. So that's why you have to work with your tax preparer, your financial advisor, your attorney to ensure that, hey, we think that this trust is going to have a good year. We need to make distributions on behalf of the beneficiary so we can lower that tax liability that may come to be. One easy way of distributing money to the beneficiary is through the stable account, through the ABLE Act. You can transfer up to $18,000 a year in 2024 to the stable account. And that distribution would be pushing $18,000 on the tax return to the beneficiary. There's pros and cons to that, and we'll get into that at the end of the presentation when we talk about stable accounts. But I just wanted to throw that out there as one suggestion of moving money out from the trust to the beneficiary, but also protecting the money through the stable account. So now we're going to talk about care management services. The trustee typically is the first care manager. However, care managers, or the trustee can hire care managers in order to do that day-to-day checking in on the beneficiary to make sure, hey, are this person's needs truly being taken care of? Because what we have seen over the years is when mom or dad dies, and who were the trustee, who were the care managers of their beneficiary, and now a sibling is the new trustee, but the sibling, has their own family, or the sibling lives in California and the beneficiary lives in the Cleveland area. They don't have eyes and ears on a daily, weekly, or monthly basis on the beneficiary to determine, are they having any issues? Are they having any issues with their group home, with the DD board, with their benefits, with their medical equipment? The professional care manager would be the person to report to the trustee to say, hey, I had my monthly meeting or my quarterly meeting with the beneficiary, and yeah, they need we need to do something with their bathroom. They need grab bars. They need to update their bathtub because they're just having trouble. Maybe a walk-in shower would be more beneficial. So those kinds of things, a professional care manager can take that role that the parents used to have, those eyes and ears over the beneficiary. This professional care manager would be the advocate for the beneficiary. So they would identify these problems, offering solutions, and encourage that the beneficiary be as independent as they can be, because that's what everyone wants. We want the beneficiary to live life to the fullest as independently as they possibly can be. Some beneficiaries, although they're disabled, maybe they do work. Maybe they do have a part-time job. Maybe they're in a day program. And if that day program closes or they're having issue with their employer, the professional care manager can be that advocate to report to the trustee, let them know the situation, report to the family members for that matter. It doesn't always have to be the trustee. The trustee can have family members involved to work as a team to help, make this beneficiary as independent as possible. So what we put in our trust, we put this advocacy provision in there that allows the trustee to hire this advocate, and we put in general duties of the advocate, which are listed here. Assist with and monitor government benefits. I had one client recently. She has a mental health diagnosis, and she is in a group home, and she's on Medicaid. She is receiving Social Security disability insurance, but the group home said, well, we're raising our rent, so we need, and the rent is higher than what her Social Security is. But our professional care manager, Janelle, and she's going to be on the next slide here, is she worked with the group home in applying for RSS benefits, residential support services benefits, which is extra income from the state to cover rent and those expenses. So that's one example of what Janelle did in our office for a recent beneficiary of ours. They make regular visits to the beneficiary, and that can be to the needs of the beneficiary. It could be phone calls. It could be a monthly meeting. It could be a meeting twice a year or every quarter, just to check in on them, make sure that, hey, is their apartment clean? Do they need other caregivers? Do they need a new caregiving company? Do they need a new group home? She works very closely with the DD board. If the DD board is in, if the beneficiary is receiving some sort of waiver from the DD board, she works very closely with Job and Family Services to make sure that, yeah, they're on the right program to receive the services that they need to receive. Ultimately, she's going to provide a report to the trustee, whether that's a constant report, whether that's a formal report, to say, yeah, this is, her needs are being cared for, let's keep doing what we're doing, or hey, the beneficiary needs a little bit more, a little bit more distributions for these reasons, and the trustee can use that information to help better the beneficiary. So once again, the trustee is delegating responsibility to a professional care manager. So this is Janelle. This is our professional care manager at Hickman Lowder. Hickman Lowder was one of the first, um, law firms in the nation to hire a social worker to help with our elderly clients and our disabled clients, as an advocate. Um, she she's wonderful. She has many clients. She knows the systems in and out. She is on a lot of boards, to help advocate for our elder and disabled clients. Um, these trust resources can be used to pay for professional care managers like Janelle. It doesn't have to be Janelle, but Janelle is one of the best. All right, George, you're up.
All right. So circling back again, reporting requirements, a little bit more detail about these beneficiary, these reporting things to, Medicaid and SSI and all that. So, these agencies, they don't know automatically when things like these trusts are created and when distributions are made. They mandate that the individuals involved, that they report these events to the agency. So when the trust is created or funded, and by funded means that when assets go into it for the first time, when the beneficiary is entitled to have distributions made, they need to be informed, because that may impact their benefits. Although if it's been a trust created by somebody like us, it shouldn't, because it will be structured correctly. You have to report whenever countable distributions are made, which that shouldn't happen, but you should certainly make sure that you are working with attorneys that understand these rules, so that you avoid making countable distributions. But if countable distributions are made, they have to be reported. Medicaid, Social Security, they can request a full accounting of the trust activity, whenever they desire. And then again, when the beneficiary shows income from the trust on their tax return, that's going to be something that you'd want to be able to explain and to the benefit agency, if they ever ask. Go ahead, next slide. Social Security. Social Security has reporting requirements that they want to be had. They want to be kept informed of certain developments with the beneficiary, recipient of those funds, and they want to be informed in writing within 10 days after within 10 days after the month that the event occurs. So if the beneficiary moves, if they change address, if their income changes significantly, if they start receiving a new income source, or they stop receiving income from a certain source, if they have a significant change in their accountable resources, if they suddenly have received a lump sum from an inheritance or settlement or something like that, or if they are now eligible for some new public benefit. So if they've turned 65 and are now eligible for Medicare, or if they've been on disability for 2 years and are now eligible for Medicare, or if they started working part-time and now they're eligible for the Medicaid buy-in for workers with disabilities, that should be reported to Social Security. So Social Security puts it on the individuals to let them know if they are no longer disabled. So, and we'll get into the details here later on, but disability means able to work. So if they have improved to the point where they are now able to work and earn income sufficient to meet their needs, engage in substantial gainful activity, then they are by definition no longer disabled, and Social Security needs to be told that so that they can stop benefits. If Social Security finds out after the fact, then you run into issues where there's overpayments, that are assessed, and penalties, and all sorts of a mess. So, it's great if an individual does improve and is able to start earning, their own living, but that needs to be reported, because you don't want to run into overpayment territory. If the beneficiary gets married or gets divorced, that has an impact on benefits. Social Security needs to know. If they're admitted or discharged from a facility like a hospital or a nursing home, and I would take this to mean if it's been a significant change in their regular status. So if they've been living in a nursing home, and they are discharged out to the community, or if they've been living in a community and now they are going to be moving into a nursing home or some other facility, that needs to be reported. If they've had a couple of days stay in the hospital, I wouldn't think that would need to be reported necessarily. And then this one trips people up a lot: any intended trip outside the United States. And I think this is for purposes of just making Social Security aware that the individual will be traveling outside the United States, so that they have a heads up about any activity that then shows up later on with expenditures in foreign countries, or foreign involvement in assets or things like that. The important thing to remember about this one is that this isn't, the Social Security doesn't have to give their permission for somebody to travel outside the U.S. They simply need to be kept aware so that they don't flag things as being a problem, or something like that. So I think that's how you want to take that requirement for reporting. So you reported something, you reported a change, and your attorney has told you that it's not going to be a problem. This isn't going to affect their benefits. It will not affect their benefits, but nevertheless, the result is that these benefits are interrupted or terminated or denied. You can file an appeal. You should file that appeal as quickly as you can. Certainly within 10 days of the receiving the notice, at an absolute minimum, within 10 days, within 10 days following whenever they are actually terminating the benefits. If you do that, then your benefits will be continued while the hearing is scheduled, and then until it's decided. So you have,
sorry.
That's all right. So Social Security gives you 60 days to appeal. Medicaid gives you 90 days, but there's a much shorter threshold if you want to preserve those benefits. So even if benefits are in fact terminated, but you still appeal within the longer time frame, and you win, benefits go retroactive, back through that. So there won't, at the end of the day, there won't be a gap in benefits. All right. This, you want me to keep going, Ethan? Do you want to jump in?
Do this next one, and I'll jump in after this.
Okay. So, a trust is in many ways, a more sophisticated form of just estate planning. What's going to happen after somebody passes away. So if you have a special needs loved one and you have included them in your estate plan, your estate plan should be reviewed periodically. Just make sure that everything is arranged correctly so that what you expect to happen after you pass, it does in fact happen. If the people that you are thinking will take over as far as the advisors and trustees and advocates and whatnot, make sure that the documents in fact name the people that you intend. That you may have set up this trust 25 years ago, and you put your brother in charge of as the successor trustee, but now you may want to take him out and replace him with your one of your adult children. So making sure that gets updated. If your beneficiary's condition or eligibility has changed, 25 years ago you were very concerned that your special needs loved one wasn't going to be able to ever make it on their own, and they surprised you. It turns out that they're more capable than you were led to expect, and you may need to adjust your estate plan accordingly. If your economic situation changes, maybe 25 years ago you had your assets were much lower, and so you arrange things accordingly, and now you have been successful, and you want to make sure that your success is able to be passed on. Maybe we need to update the estate plan. Again, personal changes, your situation changes, or just even if none of this has happened, meet with the attorney every few years, 3 to 6 years. They change these laws all the time. New things are added, rules are changed and updated. Meet with them so that way you make sure that your trust reflects the current state of the benefits laws, so that, again, what you intend to have happen, in fact, does happen.
So back to Social Security, to qualify for Social Security, there has to be some sort of physical or mental impairment. It has to be, that impairment has to last 12 months or longer or result in eventual death. So having a broken leg does not qualify one to qualify for Social Security. They will hopefully get better and get back to working. This would be mainly for substantial gainful activity. Can this person work enough to have substantial gainful activity? The dollar amount of that in 2024 is $1,550 a month. So if they are able to be employed and make more than $1,550 a month, and that's gross income, then they do not qualify for Social Security. The way that we tell clients is, if you're worried about that substantial gainful activity, level, then maybe not work enough hours to still qualify for that Social Security. And that Social Security standard is with SSDI, Social Security Disability Insurance. So you can work part-time, receive Social Security, and still receive the benefit of your monthly paycheck and still qualify, for SSDI. So SSDI here is for those that have worked enough into the system themselves to qualify to receive Social Security based on their own work history. After you apply, there is a 5-month wait before Social Security benefits will kick in from the time that Social Security states that you're disabled. So why that 5-month wait? Well, the cold-hearted truth of that is Social Security is going to see if that beneficiary is going to survive. And they don't have to pay out benefits then during that 5-month probation period. Medicare is connected to SSDI. So 24 months after the date of disability, that person will qualify for Medicare. So once again, that 24-month lag is them banking on, not banking, but them assuming, hey, is this person going to survive the next 2 years so we don't have to pay them Medicare? That's in the Social Security rules, that's in the the federal code. However, if there are other ways a child can receive SSDI, and that's through childhood disability benefits. And also we call it DAC, disabled adult child benefits. That's what the prior term, and it kind of just stuck. It's based off of the parents' earnings, and the rule is if the child is disabled before the age of 22, they would be able to receive SSDI based off of their parents' work history. That starts when the parent retires, becomes disabled, or passes away. That benefit is 50% of the parent's benefit. When that parent passes away, it becomes 75% of the parent's benefit. So it's a great, exception to the rule. You don't really hear too many times that the law benefits a disabled individual. This is one of those. It's always based off of the highest parent, the highest earning parent. So if one parent retires and the child is receiving SSDI based off that parent's work history, and then the other parent dies, and they would receive a higher benefit from that deceased parent, it would jump to that deceased parent's work history. So it's always going to benefit the child more. The SGA limit is still relevant. SSDI is not means tested, meaning this person can have assets. They can still work part-time, but they can't make more than that $1,550 level. SSI and Medicaid, these are the means tested benefits. This is for children that become disabled after the age of 22 that don't have a work history. They would qualify for SSI benefits. It's the same disability requirement that Social Security has, but they look at assets, they look at income to determine, does this person qualify? Applying for Social Security, either Social Security program, you start that application online at ssa.gov. For SSI application, attorneys aren't involved in that initial process. Attorneys can become involved once the application is denied. Then a Social Security can jump in. Then an attorney can jump in and try to fix the application and get that person approved. So here's our question portion. If anyone has any questions, they can feel free to put it in the chat. But I'm just going to keep going for time concerns here. So we have income versus resources. So we're talking about SSI and Medicaid, remember. This is a means tested program. So income the receipt of income in the month that it's received will affect that person's benefits, the SSI benefits for the next month. So if they're working and they receive $1,000 in income in the month of June, that will affect their SSI benefits the next month. If that income received is spent down that month, it will not be considered an asset for that next month. Once again, there's a reporting requirement for income. Typically, if a beneficiary has been working, that Social Security will know of the income. There's a way of the representative payee for Social Security, or the beneficiary for that matter, to report income from their wages directly to Social Security, or they have to report their their pay stubs to Social Security on a monthly basis. So when someone's on SSI, there are certain rules regarding income that the person's receiving. You disregard the first $20 of unearned income. Social Security has a very broad definition of what income is. So it's not just working income, it's also money being deposited into the person's bank account from a parent or from a trust. They count that as income, which is why we talked about before, we don't want to give money directly to the beneficiary, especially if they're on SSI and Medicaid. If it's earned income through work, they disregard the first $65 plus 1/2 of the earned income. If they make $1,000 a month, you subtract $65 from that, and then it's the next, $500 or so is also disregarded. The other amount, the other $500 would reduce their SSI for that next month. There's deeming issues, meaning if a minor child is receiving a minor child typically does not receive SSI benefits because parents' income and parents' assets deemed to that minor child. So that's why at age 18, that child can now apply for Social Security and qualify because the deeming no longer affects them. We talked about in-kind support and maintenance a little bit. That's dealing with the food and shelter expenses. The food is no longer applicable here. But if a child is receiving payments for shelter expenses from their parent, well, that could be considered in-kind support and maintenance, and also lower their SSI payments. And obviously, with the Medicaid spend down, we want to make sure that the income that's received is spent down that month then, so that next month that's not considered an asset anymore, and they still qualify for SSI. SSI has that $2,000 limit. And I see some questions have been popping up. So yes, one question was S&T is the state is as the beneficiary. Yes, the special needs trust is that Medicaid payback trust. The state, at the beneficiary's death, the state is the first beneficiary of the funds that are left, that they're paid back first. The other question is, how are benefits for adult beneficiary effective if higher paid parents' pension is through the state teacher retirement system? So we're only talking about Social Security, and Social Security this is where the DAC benefits come into play, not with the pension benefits. So if one parent is receiving a pension, and a part of that pension, if they die, part of their pension goes to a disabled child, that's unearned income to them. That should not affect them receiving DAC benefits from their other parent that receives just plain Social Security. So a child theoretically could receive a pension benefit and a Social Security benefit. Then another question is, should an account for a wholly discretionary trust be established when the trust is created, or can the trustee establish the account when needed? Also, when is the trust assigned an EIN? So if you know that if you want to fund the wholly discretionary trust, a third-party trust, then that's when you need an EIN. Typically, we don't generate the EIN unless we get that instruction from the client. Because typically these third-party trusts are established when the parent passes away, or not established, but they're funded when the parent passes away. At that point in time, an EIN is generated, and so that person the new trustee can go open up an account under the wholly discretionary trust. So it all depends. You can fund the trust while you're alive. You can start an account under the third-party trust name, or you can just have the document there and make sure that your beneficiary designations on your account go to the trust. And then at that point in time, the new trustee would have to generate a new EIN for that third-party trust. Another question, for life insurance and retirement accounts, should I make the trust the primary beneficiary? Would it be the wholly discretionary trust? Yes, you should have the trust down as the beneficiary of the accounts. It depends on what kind of trust that you have. If you have a family trust, and the wholly discretionary trust is a sub-trust of the family trust, because you have multiple beneficiaries, multiple children, then you would want the family trust to be the beneficiary. If you have just one child or one account designated for the disabled beneficiary, then you would have the wholly discretionary trust as the sole beneficiary on that account. So we talked about income. Now we're on the resources or assets. Assets for qualification for SSI and Medicaid for that matter is owned by the individual themselves. Trust assets, that's exempt. These resources are owned exclusively by the beneficiary. They have to be available to the beneficiary. That's another topic here, because I've had clients that they have like an UTMA account, a United Transfer to Minors Act account, where a parent or another individual is the custodian of an account until the age of 21. Well, yes, the account is technically owned by the individual, but they don't have access. It's not available to the individual until the age of 21. So that is not considered a countable resource for SSI purposes, or it shouldn't. These resources are not exempt. So we're talking about bank accounts. If they receive an inheritance directly to them, of an IRA account from a family member, that asset is their asset. They don't qualify for Medicaid anymore. We have to establish a special needs trust or an ABLE account to make sure that those benefits are protected. Deeming, we talked about that. Deeming stops at age 18. So once you turn age 18, that disabled individual can apply for Social Security, can qualify for SSI, because their parents' assets are their parents' assets now. There's no more deeming. Exempt resources that an individual can have, these are the main. There's a lot of smaller exempt resources. one that I see here that's not listed, or it is listed, it's the first one, household goods, that's personal possessions. Think of like clothing, furniture, stuff like that, that's exempt. They can have a residence, they can own a house, they can own a condo, that's exempt. At least one vehicle. If they have multiple vehicles, well, the other vehicle has to be is included in that $2,000 allotment that they have. So that vehicle has to be less than $2,000 included with their other cash accounts. An irrevocable funeral contract, burial plots, those are exempt. A whole life policy is also exempt, but the face value, the cash value of that policy has to be below $2,000. Other exempt assets that might come into play, Social Security back payments. If Social Security says, "Oh, we should have paid you $20,000 more money over the past 3 years. We're sorry. Here's $20,000." Well, $20,000 is a lot of money, and especially it's a lot of money for someone that's on benefits. You have 9 months to spend that money down before it will disqualify that individual from SSI benefits. Medicaid exempts that back payment for 6 months. So if they're on Medicaid, you have to be wary of that. If you say, Ethan, I don't need to spend this money, down, I want to save this money. Well, that's where you can put it into an ABLE account. You can put it in a special needs trust account. That transfer is exempt. That account is exempt as it's listed there below. So special needs trusts, first party trusts are exempt. Third party discretionary trusts are exempt, and ABLE and stable accounts are exempt. George, you want to take over the Medicaid portion?
Yeah, I can jump in here. So what Ethan was just talking about is Social Security. So this is payments to the individual, monthly checks, either from SSI or Social Security Disability. Medicaid is providing health insurance, and as we'll see, perhaps a lot of other services and supports that the individual also requires. So, the Medicaid is means tested. It is a state administered program, although there is an overlay of federal rules that provide what the states can and cannot do, and there's some federal funding that is provided, but Medicaid is state by state, administered under state law, and in Ohio is administered by our local county departments of Job and Family Services. So it is means tested. Various Medicaid programs have different resource requirements, but at the basic level, an unmarried individual can have no more than $2,000, and their income has to be below the applicable federal benefit level. This year it's $943 a month. This tracks directly with SSI rules, and in fact, Medicaid at a basic level carries the same rules, can be no more restrictive than the SSI rules. So you'll see in many respects the SSI rules and the Medicaid rules are parallel to one another. So go ahead. Then, in addition to health coverage, so paying for doctors and hospitals and medical procedures and all that, there are also what we call the Medicaid waivers. And this waiver word trips people up a lot, because when we often will say, okay, well, we need to make sure that we need to apply for a Medicaid waiver for your special needs loved one. And I think just saying that, people assume that we're asking for Medicaid to give a waiver of some sort to the individual. and allow them to get something that they, you know, otherwise wouldn't be able to get, or something like that. And that's not what we mean at all by Medicaid waivers. The Medicaid waiver is the state getting a waiver from the federal government, from the Centers for Medicare and Medicaid Services, from CMS, to use Medicaid funds that were technically supposed to go for long-term care nursing home or some other Medicaid benefit group, and use those dollars for non-medical services and supports for people who are living in the community. So in Ohio, we have more than these, but these are the main Medicaid waiver programs that we have, and we have some that are administered under the DD board in the DD system, and we have some that are administered by Medicaid and the Area Agency on Aging under the Medicaid and Department of Aging auspices. And so the DD administered waivers are known as individual options, the level 1 and the self waiver. The Medicaid administered waivers are the Ohio home care waiver, the assisted living waiver, and the passport home and community based services waiver. And here we see, you know, for Medicaid for these Medicaid waiver programs, they have a higher income limit. So your income limit is 300% of that federal benefit SSI rate, $2,829 a month in 2024, and in many cases, that income limit can even be surpassed through the use of what's called a qualified income trust, or a Miller trust, to essentially arrange for that income to not be countable for Medicaid. So we see this a lot in the nursing home context, where somebody may have a pension and Social Security and may be getting gross income of over that limit, but nowhere near the $9,000 a month they need for a nursing home. You can still get Medicaid. You just have to use one of these QIT accounts. So another one of the waivers is the Specialized Recovery Services waiver. This is a relatively newer one, and this provides a insurance coverage and supports and benefit coordination for individuals really in two broad categories. Individuals who have severe and persistent mental illness, so people who have severe schizophrenia or severe, major depressive disorders or things of that nature, or individuals who have a chronic condition, a certain chronic conditions, largely cancers, but also HIV/AIDS, end-stage renal disease, soft organ, needing being on the transplant list. These individuals are eligible to receive Medicaid coverage under the Specialized Recovery Services Program. And the key here is, there's that income limit, and with SRS, that's a hard income limit. You can't use a QIT to get around that. But if your income is below that amount and you meet the qualifying conditions, which are somewhat convoluted, but if you meet those conditions, you can get Medicaid insurance coverage without requiring any sort of asset spend down or asset limit. So somebody who gets a cancer diagnosis and is able to get SSDI, they're severe enough that they get Social Security disability. They don't have to spend down their assets in order to get Medicaid. So long as their income is below that $28, $29 a month, they'll be able to get Medicaid without needing to spend down their assets. And this is really useful for individuals who are newly eligible for SSDI, who have that 2-year waiting period before Medicare becomes available. they may not have any other alternative for health insurance. Their Social Security disability benefit is more than what allows them to get Medicaid, generally. But they have a lot of medical needs, and they can't get Medicare because they've got to wait that 2 years. SRS is a great way for there to be a bridge of that gap for that individual. Another Medicaid program. I don't know if this counts as a waiver or what. It gets a little convoluted, but the buy-in for workers with disabilities. So a lot of individuals who have disabilities nevertheless are able to work and able to earn a living, but they may not be able to afford health insurance. They may not be able to do enough to work enough hours to qualify for affordable insurance through their employer. Their employer may not offer health coverage. But nevertheless, they need health insurance. So the buy-in program allows somebody who is employed, either part-time or full-time, to get Medicaid with expanded resource eligibility criteria. They can have more resources in the bank. They can have, up to $14,000 and change here. I think that's 2024 number that gets adjusted annually. They are able to get income, earn income. They can get up to 250% of the federal poverty level, plus an additional, I believe it's additional $20,000 on top of that earned income in the year, and still get Medicaid. They don't even necessarily have to be receiving disability benefits, but so long as they would otherwise meet that criteria, the persistent condition lasting for longer than 12 months or expected to be lifelong. If they meet those categories and they're working, they're still able to get Medicaid coverage under the Medicaid buy-in program. So that's really useful for a lot of folks as well. Go ahead, Ethan.
So I'll jump in here, George. So we talked about how to qualify, you're disabled, how you qualify for SSI. This is just a little bit more information about SSI. We want to make sure that assets are below $2,000. The 2024 benefit is $943 a month. That's either paid to the beneficiary or to the representative payee. If the beneficiary is unable to manage the funds themselves, Social Security will appoint a representative payee on their behalf. Most likely, that's the guardian. Social Security does not recognize a power of attorney, but they recognize a representative payee. So as part of the application process, the Social Security can appoint a representative payee for the BSSI. We talked about the in-kind support and maintenance rule. Essentially, the one important rule is that if a person is receiving payments for their shelter, then it will reduce their SSI amount. Right now, that's 1/3 of the value plus $20. So instead of receiving the $943 a month, they'd receive a little more than $600 a month if someone else is paying for their shelter expenses. We provided some case examples here, which I'm just going to skip through for time constraints, so we can get to the end of the program. We talked about this transition timeline of a minor won't receive SSI benefits and Medicaid benefits because those benefits, those assets and income deemed to that minor child. And the question becomes, what happens when our child becomes 18? Well, that's when we talk about guardianship. If that person is unable to make financial or healthcare decisions on their own behalf, well, a guardian would be able, through the probate court, would be able to make those decisions on behalf of that disabled now adult. Guardianship is not always the best way, though. You know, if they are able to understand a document like a power of attorney and able to sign their name to that power of attorney, then there's alternatives to guardianship to consider, which is powers of attorney. So just because someone is disabled does not mean that they are incompetent, that they need a guardian. So one way that we counteract those shelter expenses from affecting now the 18-year-old is we utilize a room and board agreement with the parent or with the owner of the house that the person's living with, that they pay a monthly rent to that owner. And that will reduce that in-kind support and maintenance deduction that they will now receive the maximum SSI benefit. They do have to pay that rent to that owner, mainly that parent or sibling for that matter. And that sibling can use that money to benefit the beneficiary. But this is the way that we counteract and try to get that SSI benefit to the maximum amount or close to. This is the typical timeline and, of when a parent retires, that beneficiary, that child might be eligible for DAC benefits now. They are on SSI, parent retires, and now they might receive SSDI benefits. And that's 1/2 of that benefit, if you recall. If that parent dies, they receive 3/4 of the parent's benefit, and now they are Medicare eligible after that 2-year probationary period that Medicare requires. The great news about this is that the Medicaid benefits for that DAC child will continue. They are grandfathered into the rules. So at the end of the day, a person can be on SSDI, Medicare, and also have Medicaid as their secondary insurance. And that Medicaid is especially important if they are receiving a Medicaid waiver, like the IO waiver or home care waiver. So obviously, this is trustee school, and this is where we get into the nuances of the trusts that we create for disabled individuals. And there's 2 broad categories. There is the third-party trust and the self-settled first-party trust. Attorneys like to call them D4A trusts from the federal code that establishes that trust. The self-settled trusts have that Medicaid payback provision, meaning at that beneficiary's death, it's paid, the monies that left in that trust is paid back to the state. The third-party trust does not have that Medicaid payback provision. They are administered mostly the same. The biggest difference is this Medicaid payback provision. So you might say, well, Ethan, why don't we just use third-party trusts? Well, you can't commingle first-party money with third-party money. If you commingle those monies, the third-party trust becomes a first-party trust. And if that's the case, you would have to differentiate the funds. And if you can't, then it all becomes first party money. So depending on where the money is coming from, depends on what kind of trust needs to be established and where the funds should go. So third-party trust, that's provided by Ohio statute. The funds have never belonged to the beneficiary. They have no access or control over these funds. Only the trustee has the discretion to use or not use the funds on the well-being of the beneficiary. This is what we use for estate planning purposes for parents, grandparents, other family members, in order to protect, the beneficiaries' benefits and protect these monies after the beneficiary passes away. The monies left over in a third-party trust stay in the family, or they go to charities. Wherever the grantor, the settlor of the trust, has drafted in the document, that's where the money is going to go. It's never going to go back to the state of Ohio. Self-settled trusts or that Medicaid payback trust, they are used with funds that the disabled individual owns, typically from an inheritance directly paid to them. Litigation proceeds, they are, in a personal injury case or a birth injury case in case of a minor, those funds are directly paid to that individual. Child support in castle cases, for a divorce setting or a child support setting, if that person is disabled, child support can continue past the age of 18 and can continue for life of that individual. That child support after the age of 18 is considered income to that beneficiary. So we would have to establish a special needs trust in order to receive that money, so the benefits aren't affected. And like I said before, improperly drafted third-party trusts or the commingling of the assets with a third-party trust means that a self-settled first-party Medicaid payback trust needs to be established. The nuances of a Medicaid payback trust, it can be established by a parent, a grandparent, or the beneficiary themselves if they are competent. And they have to be below the age of 65 for this trust to be established. If they are incompetent, that's where a guardian or the court themselves can come into play and establish this trust on their behalf. And I always put this in here that has that payback provision to the state at that person's death. And that's from birth until death of the Medicaid benefits that Medicaid has given that individual. So you might say, well, Ethan, what if I'm over the age of 65 and I receive this money? I can't establish a special needs trust and my benefits will be protected. Well, in Ohio, you can utilize a pooled Medicaid payback trust. A pooled trust can be a first party or a third party trust. It's managed by a nonprofit organization. So a nonprofit company that we utilize is Community Fund Management Foundation. And this nonprofit is considered the trust advisor. They are in charge of distributing assets, doing the tax returns on behalf of the trust account. What this means is people from all over the state and beyond our state can fund their money together. They can pool it together. And that allows the company then to invest this money collectively. So if you have a $20,000 account with this, or $20,000 in funds, you can't really invest that money too easily with, with investments or CDs. But if you pool it together, now this company has over $100 million in assets, and they have greater flexibility, and the gains and the losses, for that matter, are collectively utilized throughout the trust. In a pool trust, there's a designated advocate where they can request funds on behalf of the beneficiary. They can receive bank statements to make sure that the investments are being invested the way that they intended. And the last bullet point here I have to make is utilizing a pool trust is great, but there's a lot of red tape when dealing with nonprofit organization. There might be a 2 to 4 week lag in getting a distribution request approved. A distribution request might be denied. So it's not as easy as you writing a check, making it payable to the vendor, and getting that item paid for. It goes through a committee to review requests and ultimately being paid. So there's pros to utilizing a pool trust. There's cons. Ultimately, it might be the only option for this person to retain their benefits. George, why don't you start off the able, and then I can finish it out.
Okay. If I could, I wanted to just make a couple more points about the pooled trusts. We also, so there's 2 pooled trust companies available in Ohio. So there is Community Fund. There's also Disability Foundation. A lot of that red tape that Ethan went over, I have found is less so with using Disability Foundation. So we lately have had better ability to have more responsive and easier to work with pooled trust distributions from Disability Foundation. And another big advantage to pooled trusts is you can often avoid ongoing probate court oversight for that trust. You know, if you have an individual who is incompetent, who has a guardian, who needs to establish a first party special needs trust, if they establish a private special needs trust, the court's going to maintain supervision over that. Whereas the individual who is who has a pooled trust, that administration happens over the pooled trust, and the court doesn't need to be involved. I see a comment here that the distinction between capacity and competency, and the reason why we'll use the words competent and incompetent is that those have legal meaning. There's a distinction between capacity and incapacity. Capacity is a medical or a circumstantial situation. You know, if I am injured and I am given a lot of pain medication, while I'm on that medication, I am incapacitated and don't have the ability to do certain things. But when that medication wears off, I am back to my capacity, my original capacity, and I've reestablished it. Competency is the legal status that somebody has as to whether or not they have a guardianship established over them, and that has consequences. The only entity that is able to determine whether somebody is competent or incompetent is a court. Now the court has to rely on medical evidence to a reasonable degree of medical certainty, but it is ultimately the probate court that determines whether a person is competent or incompetent. So we use these terms not to be callous or to be indifferent to the individuals, but those words have a legal meaning, and so conflating capacity with competency can often confuse the issues. Somebody can be incapacitated, but not necessarily be incompetent. So that's why when we say if somebody is not competent to do to create their own trust, that means that they've been determined so by a court, and so that means legally speaking we have to follow certain rules and provisions. So on to the ABLE Act. This is relatively new legislation, although it's been since 2014, so it's going on 10 years now. This was part of the major overhaul of the healthcare system that was done, at that point in time, the so-called Obamacare, the Affordable Care Act. It was part of that that whole overhaul. And initially, the idea here was, special needs trusts are great, but special needs trusts are complex. They're expensive. You've got to hire lawyers. You've got to go to court. You've got to do all this stuff to have a special needs trust in place. Maybe we can do something that can avoid all of that. And so this was that attempt. Now, in the sausage making process that is legislation, the ABLE accounts got watered down a bit so that they aren't a complete replacement for special needs trusts, but they are still quite useful. The interesting thing, at least to me, about the ABLE Act is that unlike the rules governing special needs trusts or SSI or Medicaid or all that, the ABLE statute is under the IRS code, not under the public health code. 42 USC is the public health laws. The IRS code is a different provision that the citation escapes me at the moment. The way that the ABLE Act works is that states set up their own systems under the structure and framework of the ABLE system. And go ahead and go to the next slide, Ethan. And really, the way that I describe the way that ABLE accounts work is if you've ever thought about or explored 529 savings plans for college, that is essentially what an ABLE account is. It's like a 529 plan, but instead of educational expenses, they are for disability related expenses. So this is the way to think about these. So in order to be eligible to have a stable account, right now, the individual must have been determined disabled prior to age 26. Now, in a year or so, that age limit's going to be raised to somewhere. I think 40, 45, 46, something like that. But they have been determined disabled before age 26. Either formally by Social Security, making a disability determination, or they're able to demonstrate that they would meet that criteria for Social Security disability. The inability to engage in substantial gainful activity due to a physical or mental impairment, 12 months, or expected to end in death. Person can only have one ABLE account, but they don't have to reside in the state where that ABLE account is created. And as with these, Ohio is actually one of the flagship states for these ABLE accounts. Ohio calls it their stable account for a state ABLE account, and Ohio's program has the reputation for being one of the best. So people from all over the country use Ohio stable accounts for their beneficiaries' needs. So, again, you have to show that you meet that disability test. But again, one of the interesting things that this being under IRS rules, there is essentially a way where you can basically self-certify that yes, I am indeed, I do indeed meet that disability test. You have to be ready to demonstrate that if ever asked, but you don't actually have to get approved or go through any sort of approval process to establish a stable account, at least initially. So the an able account can be opened by certainly the disabled individual themselves, the owner, or then there is a list of priority, sort of a list of people who have preference for establishing that account on behalf of that individual. And, so and there's a list longer than those three, but the most frequent ones there are that parent, that individual's parent or their guardian or their power of attorney, or that also included in there is their spouse. Also included in there would be their support administrator for under Social Security, things like that. There's a whole list of people who can establish this account on behalf of the beneficiary. Anyone can contribute to the ABLE account. But remember, that person can only have one ABLE account. Now, that contribution can come from a person, or it can come from a trust, or someone, an estate or corporation. Often we will have a stable account in conjunction with a special needs trust, and they work very well together because, as you'll see, the stable account can be used for more things than the special needs trust can be used. There's some rules about if you've got siblings who are both disabled, you can roll over one's stable account into the others. There's sort of nuts and bolts there that I won't dwell on here. So go ahead and move on here, Ethan. The big limitation on these stable accounts, aside from the fact that if you are your disability determination is over age 26, is the only $18,000, only the annual gift tax exclusion can be contributed to that stable account each year from all sources, total. So it's not like grandma can give 18,000, grandpa can give 18,000, mom can give 18. No, maximum of 18,000 from all sources can be added each month, or added each year rather, to that stable account. And there is a hard cap on how much can be in that stable account. For Medicaid recipients, that asset limit is $523,000. For SSI beneficiaries, that asset limit is only $100,000. So whereas with a special needs trust, there is no limit. You could have $10 million in that special needs trust, and none of it would count as available for benefits purposes. So they're useful. Stable accounts are very useful, but they are circumscribed in how broadly they can be used. Again, it doesn't affect benefits. SSI has that lower $100,000 limit. Like any of our exempt first party types of exempt accounts or trusts, there is that Medicaid payback provision. So if your intention is somebody else wants to give money for the benefit of a special needs individual, the person, you don't want to use a stable account, because if it's going to be third party money, you can create a third party trust and avoid Medicaid payback altogether. So the stable accounts, although anybody can contribute to them, their usefulness is really in the first party context, where the individual is going to be putting their own assets into that stable account. The real benefit for the stable account is that it can be used for expenses that are much broader than what would be permitted under a special needs trust. Essentially anything that is disability related. And that is defined very broadly. So it is anything that maintains or improves the individual's health, independence, or their quality of life. So, you can look at that as really virtually anything other than just outright, gifting money to somebody else could really legitimately fall under that. If somebody wants a Netflix subscription, or paying for gas money, or paying for shelter expenses, for rent, for utilities, for what have you. Again, that's the biggest advantage there. If a special needs trust pays somebody's utilities, pays their water bill, or their utility bill, or their rent, or their mortgage, Social Security is going to have a problem with that if that's an SSI recipient. But if that trust, instead of paying that gas bill, puts money into the stable account, and then the stable account pays that gas bill, then there is no problem. Social Security looks at that as just the trust transferred assets from one exempt account to another, and then the stable account, there's no restriction on the stable account paying for utilities, for housing expenses. So this is a great way to use special needs trust money to funnel it through a stable account, and you're able to get around that shelter expense restriction that comes with SSI. So it's really useful for that.
Yeah, the other point I would just make is a lot of our trustees utilize stable accounts in order to just give more financial freedom to the beneficiary. So,
That's right.
The beneficiary doesn't have to, ask, hey, can you go pay this bill, or can you go pay, I need to go shopping for clothes. Well, the trustee can, and this is a first party trust or a third party trust, it doesn't matter. The trustee can just say, hey, I put $5,000 on your card, go do whatever you want with that money. And, it gives a lot more financial freedom to that beneficiary if that beneficiary has the capacity to use that money. Or if they don't, then another family member can use that stable account, can help that individual. So it just our goal here is to make them as independent as possible. The stable account is just a useful tool as part of our toolbox here. At the end of the day, a beneficiary could be a beneficiary of a third party trust, a special needs trust, have a representative payee account for Social Security, and also have a stable account. There's a lot of, each one of those accounts has a different hat on them, meaning there's rules for each one of them, but each one of them are used for the purpose of getting as much financial freedom and independence for that individual as possible. So with that being said, that concludes our presentation here today, everyone. I'll leave the floor here. Does anyone have any questions? I see a question here. Yes, a replay will be available. Just give us a couple weeks, 1 or 2 weeks to finalize everything, and we'll have that uploaded, and so you'll have the slides and the video that you can rewatch, and if you have trouble sleeping, you can watch our presentation. You can get knocked out. So thank you, everyone. If there's any fathers out there, have a happy Father's Day, and we'll probably do this again, probably in the winter time. Give us a little break here, but we do these trustee schools at least twice a year. So if you want to come back and have a refresher, you can tell your friends that have special needs children that, hey, this presentation is available for free. And everyone, have a great weekend.